All right. So hi, everybody. Thank you so much for joining me today as I'm talking a little bit about the victim assistance section, mainly the sexual assault exam program and compensation programs. Our compensation, or I mean our, as you know, our sexual assault examination program may have some recent changes. You might have heard about some of that. And so I'm not going to go into a whole lot of that. Because as advocates, it's not necessary to know exactly that stuff. So I'll give you what I have. If you have any questions, I will answer the ones I can. If there are questions I can't answer simply because I don't know, I will let you know. So I want to start out by just sharing that I have been an advocate for a few years prior to becoming a compensation specialist. And there were times when I found crime victim assistance applications confusing. I also found that I didn't know what all they provided. And so when I put this training together, I really kind of try to highlight some of the things I didn't know and what would have been helpful for me. But please feel free to ask questions at any time. This is something that is important many times for crime victims because they'll ask. They'll say, I don't want to, spend taxpayer money. I don't know. I don't want to take from someone else. And I try to reassure them, that this is exactly what the compensation fund is. This is exactly what the compensation fund was created for. And the monies that are there are because you didn't choose to spend your money this way. So no taxpayer dollars. So where does it come from? We get criminal penalty surcharges. We get some of the OWI fines and penalties. We also have Kasha, who works in our office, and he is our restitution and subrogation coordinator. And so what he will do is file like the pecuniary damage statement or give that to the prosecutors so that they can get that timely filed and that we can get our restitution. He will work with prosecutors to get restitution orders done. And then the subrogation piece, if a victim of crime receives a settlement related to that crime, then we have some subrogation rights associated to that, and we can recoup some of our monies that way. So insurance or civil litigation pays us back inmate wages, and then we also receive Victims of Crime Act money. That's federal funding that we get. So the sexual assault examination program for advocates, it's important to know that a crime victim can go to any exam site and they can get a sexual assault exam. They can get, so that could be like 3 different parts. They can be checked out to make sure that they're okay. They can have an evidence collection kit taken, and they can get prophylactic treatment to prevent sexually transmitted infections. And Plan B to prevent implantation. So it's the sexual assault exams are kind of 3 parts. You have the exam part, you have the evidence part, and you have the medicine part. And all 3 of those victims can access. They can do 1 of them, 2 of them, 3 of those things, or none of those things. But anything that they choose will never, should never be billed to them at all. We also, I know in Iowa, try hard to, when somebody's been the victim of a sexual assault, we try to give them access to a sexual assault nurse examiner who has that special training on working with sexual assault victims. And so we reimburse the nurses for their time and their mileage. We also make a reimbursement to the hospital for a facility fee. And so we pay those things so that victims don't have to. Those would be things that they would normally be charged for. And we pay it at a pretty reduced rate, but it's paid that way. And so no victim should ever, like, it's against the law to bill a victim or run it through insurance. It has to go, those fees have to go. Hi, Sarah. The facility, I can tell you what they were. And I think the nurse fee is just, I think AG Bird announced that it was $400. Oh, that's a good question about should we contact me, or not me, but our office in the hospital first. I don't suppose it really matters. It might be easiest to call Kirsten. She is the sexual assault examination program coordinator. And so so these are the fees that we had before. She would be the one who would help with hey, this person got a bill and they're not supposed to get it. She'll handle it. And I will give you, there's an email where you can access her directly specific to sexual assault questions. So for the facility fee is up to $300. It is now up to $400 for the examiner. So that's a sexual assault nurse examiner or a physician. And then lab and prescription costs of the exam for the prevention of STIs, and then follow-up appointments at the same rate as the initial examination. So state fiscal year 23, that's how many claims were submitted to our office, 2,500, just over. And we paid just over 2 million, or we paid almost 2,100,000 for examination fees. So the SAE program, a crime victim or a sexual assault victim does not need to apply to get this service. Like I mentioned, they can go to an exam site and they can have this exam done, and they automatically qualify by walking in the door and saying, hey, I would like to get a sexual assault examination. There's no requirement to report to law enforcement, and they do not have to submit a kit. And the victim nor their insurance are never responsible for this. It literally has to be billed to our program. So that while somebody who has been sexually assaulted has access to the sexual assault program and can get that exam and follow-up exam treatment, they are also eligible to apply to the compensation program. So there are two separate ones there. So if you are at a sexual assault examination, please, if it's appropriate at the time, when you're there, but refer them to our office. And this is that billing or questions. This is the way to get a hold of Kirsten Eisenhart. She's our go-to for the sexual assault exam. Any questions you have, she knows everything there is to know. So thank you for putting that in the chat. All right, so the Crime Victim Compensation Program is the next thing that I'm going to talk about. That is the program that I'm connected with. I'm just kind of doing a solid for people that normally do the training today. But this is my full-time gig now. And so who should apply for this compensation? Victims of violent crime committed in the state of Iowa. Okay, well, who sorts out what's a violent crime? And so we'll get kind of into the, if this, then that, or what abouts here in a little bit. Because I know that we used to say, just have everybody apply, we'll fill it out, or we'll figure it out. And I don't know, I think we should do a little bit more screening with that. I mean, you're with advocates doing that, saying, I don't think that's gonna, that's not something that's covered. I didn't feel as an advocate like I had a really good grasp, so I would just turn it in. I would let's fill it out, let's check every single box and turn it in. and let them figure it out. And so, which is fine, and that can happen. But hopefully with this, you'll feel a little more confident saying, let's, hold off, or, I don't want to put you through going through a whole application when I know that this is not a covered crime. So who should apply? Anybody injured by a violent crime in a state or nation without a federally approved crime victim compensation program. So every state has a crime victim compensation program. However, it may be that they are out of the country. A victim is out of the country, an Iowa resident, and they are victimized there. And so we would be able to cover those crimes. They should apply with us because they, would not have our crime victim compensation program. Where we see this a lot is, so benefits are attached to jurisdiction. So if the crime occurs in Iowa, then they should apply in Iowa. If a victim lives in Council Bluffs and they are assaulted in Omaha, they should apply in Omaha. Now, if there are things that they would like, benefits that they're eligible for that Iowa gives, but not Nebraska, they should apply for both and let Iowa know. A good example is Iowa. One of the benefits that we provide that is not real common in other states is that if somebody is the victim of a crime and they feel that purchasing some security equipment would help them to feel more safe, then we can reimburse them up to $500 to purchase. Most of the time it's cameras that people get. And so we can reimburse them up to $500 per resident. And so if they can qualify for that in Iowa, but that's not something Nebraska has, then absolutely they should apply. So am I making sense? Is that helpful?
So you said something about them, if they lived in Iowa but assaulted in another state, they had to go through the other state for compensation?
Yes.
Okay.
Yep. Compensation is tied to jurisdiction. Where the crime happened is that's where the compensation is connected. And so in those, outer, like Quad Cities or, over in Northwestern Iowa, like you get some kind of, sometimes there's some back and forth. And so if you're an Iowa resident and you're assaulted or, a crime committed against you in Nebraska, you apply Nebraska and potentially Iowa as well, if there's something that they don't cover. Because the states really vary. I mean, most of them cover medical expenses. We will cover loss of a cell phone that is held as evidence, whereas I can't remember which state it is. It's one of our surrounding states that the phone has to be damaged in the recoup of it, like as it's held for evidence, that phone has to be damaged. And that's not a benefit or it's not a requirement that we have. And so there's a little bit different. However, because they offer recoup, we'd have to look at that kind of case by case, but it is a benefit that they provide. So we would not be able to pay for their phone, but we could pay for security. All right, who should apply for compensation? This is another one, family or household members of the primary victim. And so the primary victim is the person who has the injury, emotional, physical, whatever. That is the person. So even if it's a child, the primary victim is a child. The parent will be filling out the application and signing for them, but the primary victim is the child. And so the primary victim, once approved, has benefits. And this works in homicides as well, but let's, go with kids. So this child is sexually abused by someone. And so their parent, the county attorney's like, here, apply for crime victim compensation. Okay. Primary victim is the child. Mom and dad will fill it out. Primary victim has benefits available to them. And so the parents are the keeper of the benefits. The parents themselves are also secondary victims. So they are what we call the claimant on the primary victim case. They are also they're eligible to be a secondary victim. And so we would want the primary victim application, and then also we would send them, or you can have them fill it out. It's the secondary application. There are two separate areas of benefit. So for example, a primary victim has $5,000 worth of counseling available to them. A family or household member, a secondary victim, has $2,000 available to them. And that's for their own. That's not for driving the child to therapy. The child has a transportation benefit associated with that primary application. And so mileage can be paid to the parent who's driving them, but it's their benefit because they are the injured party and they are the one getting treatment. So I hope I'm not being terribly confusing. There are no income requirements for compensation, and there are no other resource requirements for compensation. So our agency, and you'll see this again, is a payer of last resort. So that doesn't mean that when it says no other resource requirements, about if the victim is a US citizen and is sexually assaulted outside of the country. Oh, sorry. Okay. Is there something that the program can help with? Yes. If that country where the incident happened is not going to do anything. Yes. So if an Iowa resident is out of the country and is a victim of a crime, then they can, as an Iowa resident, apply for here. Because there's not a crime victim compensation program in that other country. Okay. Any other questions right now? All right. So you all know what this looks like, I would imagine. This is the primary application. So the person who has been harmed gets the green application. It looks like this. On the inside, what we're asking for, and some states, they're like, I went to a conference and there were representatives of the other crime victim compensation programs, and some of them have like 14-page applications. Oh, okay. I will get to the question is, what is the time frame to get assistance through this program? And it's 2 years, but there's some caveats that go with that. So I will get to that, I promise. Thank you for asking. All right, so this is the application, what it looks like. What we're asking for is victim information. How can we contact you? Then some information about the crime. Like, was it reported or not reported? Was it, what were the injuries? What law enforcement agency? Section 3 is, what crime-related expenses are you looking for? If you only check 2 boxes, that's okay. When somebody is approved, they have access to all the benefits. So what section number 3 does is makes us not send unnecessary paperwork to people, because I promise there's a form for each one of these little check boxes. And so, or almost all of them. And so if somebody says, well, I just want my medical records paid for, my medical expenses paid for, then I don't need to send them information about lost wages due to attending criminal justice proceedings. We can get to that later. But initially, it's not, oh, yep, I promise you I will answer that question as well. So quick answer is no. There are lots of valid reasons why people don't report to the police, but we'll ask them if they did or not. It's not an exclusionary factor if they have not reported it. But when we get this, the first thing we do is contact the police department. If they say, yes, I reported it, the first thing we do is ask for the police reports, because we're trying to get, what was the victim's statement? What did they say happened? So we're looking for the who, the what, the where, the when. Then also, oops, sorry. And then we have this page. So sometimes I just want to encourage you all to, we cannot make any payment unless Section 1 is signed. And so a lot of times we'll get applications back, and that's that subrogation agreement saying, I know that if I am paid through an insurance settlement, the defendant's insurance, or I'm paid through a civil judgment, that crime victim assistance can recoup their expenses. And then, so we do ask them if they're represented by an attorney, and then Kasha will connect with that attorney. And they'll work out how that all shakes out. Section 2 is an information release, and Section 3 is a mental health release form. And so this is where we ask, are there any physicians that you saw? Are there any mental health that you saw? Many times they're filling this out before they have any idea if they're going to get therapy, any mental health services. So we would ask that they go ahead and sign sections 1, 2, and 3. The reason for this is it saves us time later. We don't do anything with it, but if they call and say, hey, or we get a bill from a therapist, I can't pay it until I have this signed. And so we send no communication out to anyone unless there's a name, address, phone number. So the victim is therefore directing us to send that out. They do not have to put every doctor that they've ever seen on there. We are looking for people who treated them for that crime-related injury so that we can pay the expenses associated with that. So violent crime, a forcible felony, aggravated or misdemeanor involving the actual threatened infliction or physical or emotional injury on one or more person. So what these would be some examples of what they, but that's, including these, but not limited to this information or those topics. So what we're looking for is that a crime was committed. So what this action that happened is 1, against the law, and 2, poses a substantial threat of injury or death to a person. We're also looking for, does the person applying, did they suffer a personal injury or death as a result of the crime? A personal injury absolutely is emotional injury. So it includes bodily harm or mental suffering. So that's really kind of what we're looking for, and to be able to compensate those crime-related, the crime-related expenses that they have. So let's talk about property crimes, because that's really, when I would go in and I'd be like, okay, just fill it out and mark everything. I can tell you that the theft of a car from a driveway where the victim is not standing next to the car and in immediate, having a risk of immediate danger, and the car is stolen, that is not a crime that we cover. And so that should be referred to, if it happens to make it to court, restitution. I can tell you that if there's a criminal mischief and I had a case recently where a woman let somebody stay in her house and they trashed the room and broke a lot of her property. I can't, the law does not allow us to pay for the damaged property. It gets really specific about crime scene cleanup, and I'll touch on that in a little bit. So these property crimes, however, we're looking for that threat of a personal injury or harm to the victim. So were they there? In cases of burglary or arson, we'll consider it a compensable crime if it happened at their primary residence. So even if they weren't home and their home was burglarized, that's your home. And so we would consider that a compensable crime, that burglary, or the arson. A residence also includes a detached garage, a shed, or a similar structure, and it includes a vehicle if that was serving as the person's primary residence. So if I'm living in my car and somebody breaks into it, then that could be a compensable crime. Okay, so the truth about property. Most property losses are not compensable under our code chapter. However, we can provide reimbursement for clothing that's held as evidence, if there are medically necessary items that are damaged, residential security items that are damaged or deemed inadequate. If they don't exist, they are inadequate. Cell phones held as evidence or damaged or destroyed, lost or stolen. Coming up, okay. So if an individual was in the vehicle when the aggressor smashed the window, they could seek compensation, absolutely, because there was a risk to them. There was a risk, a substantial risk of injury to them. Okay. Then cell phones, and then Chapter 915, generally, and this gets back to the question that was just asked a little bit ago, generally requires filing of a criminal report to be eligible for compensation. However, we really try hard to get to yes. And so we're able to waive this, particularly for cases of sexual abuse, child abuse, domestic abuse, dependent adult abuse. There are several reasons why people choose not to report to police. And so what we'll be looking for then is we can waive that reporting requirement if we find good cause. And so we can base our good cause on, let's say, the victim's age, maybe their physical condition, their psychological state. You can see that these are very broad brushes. Any cultural or linguistic barriers, any compelling health or safety reason that would jeopardize their well-being. So feel free at any time to call us. Some of you as advocates will see, so if somebody does, says, hey, I didn't talk to the police. We have a way that if they're working with an advocate, then the advocate can fill out a statement that says, it gives us the who, what, where, when, based on their work with that victim. So we can substantiate the claim based on an advocate's statement. And so some of you may have seen these before. They're called a Victim Service Program Statement of Crime. And so we can approve claims based on that paperwork. And so if somebody marks on that primary application, hey, I didn't call the police, that's okay. So please work with an advocate to get this statement filled out so that we are able to approve the application based on that. Other ways that we can approve things, I had a case where a woman, the only person she told about her sexual assault was her therapist. We can approve claims based on therapy treatment records. If they've reported to a doctor, a licensed practitioner, basically, if they've reported to a licensed practitioner or if they report to an advocate. That's one way, a few ways that we can get around. Those are good cause. Oh, sorry, law enforcement waiver. Sometimes, so what we do when we get the application is and people say, yes, I report it. Okay. If they reported, we ask the police and we send them a form and it says, hey, did this person, can you send us the reports for this date? This person is applying as a crime victim. And then we ask them a series of questions. And so we ask them, we're looking at the dates. Did they apply within 72 hours? Are they applying to us within 2 years? And I will get to all the exceptions of this here in just a second. And then we ask them, was this person provoking or inciting the crime that occurred against them? We will also ask, were they participating in a crime when they, when they were injured? We will also ask them, did they cooperate with the reasonable requests of law enforcement? Yes or no? And so, as you can imagine, we get a variety of answers on that, and there are a variety of things that we can do to approve a case. So, and get around that law enforcement waiver. And sometimes we just can't. An example of getting around it, the ones that you can easily think of, I don't want to report a sexual assault to law enforcement. Okay, that's okay. We don't need the police report for it. We can get it through those other means that I mentioned. So we can get it through a medical record. We can get it through a treatment record with your therapist. We can get it through the victim service advocate that was there with you when you had the exam, or you guys can do it. Okay. Our program, we will never hold a juvenile responsible for a 72-hour reporting period or a 2-year filing limit. So one of the requirements that we have is that when the crime is committed, we ask that that report be filed with the police within 72 hours. We also ask that the application be filed within 2 years of the crime happening. So I'm sure you can, as we can as well, think of about a bazillion reasons why somebody might miss that 72-hour reporting period. And so it is pretty rare that we would deny a claim for not making the 72-hour reporting period. That usually happens when somebody sends an application, they say, I did not report it, and we try to reach them, and we can't reach them. We send out like, hey, here's your local advocate. I mean, we give them an explanation and say, hey, reach out to your local advocates, and we'll give them, who those are. We'll try contacting them through email, through phone, via mail, anything we can do. We also send that victim services request to the local victim service provider. And so just to give them a heads up that this person has applied, and to see if, if they're working with an advocate that can fill that out and help us approve this. What we would deny is when we hear nothing. So that's what we would typically deny the claim for 72 hours. It's just the reason that we have. They didn't report it within 72 hours, and we haven't had a way to substantiate that the crime happened. And then the 2-year filing limit, kind of same thing. We never hold juveniles for that. But the most common reason people don't make that 2-year filing limit is they had no idea that our program existed. So, and if they just say, I had no idea it existed, that allows us to waive that requirement. The eligibility requirements for application for eligibility to our program to get compensation. This is where these are the questions that we ask the law enforcement. I probably should put this slide first. But a victim cannot have been found to be consenting, provoking, or inciting the crime that caused the injury that they're seeking compensation for. So, for example, if I decide, I'm out and Anne and I decide that we're going to fight. And so we have, okay, I'll meet you, we'll fight. And we get into a fight, and Anne is a much better fighter than me. I was consenting to that incident. Now, if Anne brings another person, I've not consented to that. If Anne brings a weapon, I haven't consented to that. If Anne, those are the two most common that were like, well, they did not consent to that happening. Committing a criminal act. A lot of times this comes up. I, thought, oh, drug deal gone bad. Well, they were dealing drugs, so that was committing a crime, and so they wouldn't be eligible for compensation. Not true. We have to, if this is going to hold that we deny something, somebody for committing a criminal act, we have to meet a two-pronged standard, and that means that we have to show the direct causation between the injury that they're asking for compensation and the criminal act that they were committing. So if I go and sell somebody weed and they shoot me, my criminal act, the selling of the weed, does not have anything to do, that did not cause someone to shoot me. So we have to find that causal act. If that's the part that we would have to show. Cooperation with law enforcement, we get a lot of different reasons on that. One of them I had, well, she didn't follow through with a sexual assault exam. Okay, well, that, cooperation for us means that they have to give a true and accurate, or to the best of their ability, have to tell what happened. They can't just give their name or a fake name, and then never speak to the police again. We need the who, what, when, and where. And so to the best of their ability, sometimes they don't know, to the best of their ability, can they provide that information? Sometimes we get cases where people decide, the police get called and they decide it is not in my best interest to cooperate with law enforcement. And you can imagine, reasons for that, that they really feel unsafe continuing to cooperate. So we have a piece of paper that we send them and just say, hey, we understand that sometimes it's not in your best interest to cooperate with law enforcement. So can you let us know, tell us a little bit about why you're choosing not to cooperate with law enforcement. And I just denied one because he said, no, I'm not afraid. I don't want to be involved. And so I have to deny that because he did not give the police, and he gave the police a false name and then just never followed through. And, it was sad because he was shot, but he had his, good reasons why he didn't want to do that. And so, we explained why, we were going to have to deny, and he understood. So any questions about that, and Ari, will you keep me good on time? I don't know how much time I'm.
Yep, you have about 15 minutes left.
Fantastic. So anybody have any quick questions, or you can have long questions too, if you'd like. Any questions for me about the eligibility? All right. So we have these three categories, and this is kind of what I was talking about. We covered primary, right? That's the person who has the injury, who has the emotional, physical, they're the person who is directly harmed. The secondary victim is their immediate family, mom, dad, brother, sister, or somebody that cohabitate, husband, wife, could be. And it could be a second cousin if they were living in the house when the crime happened. Homicide victim's survivor is anybody related by blood or affinity. So therefore, A homicide victim survivor could be cousins, aunts, uncles, grandparents. It really is much larger. The benefits are different for homicide victims survivors. They more closely align with primary. So like for lost wages due to crime-related injuries, we're able to pay up to a month of wages, of lost wages if they missed work, without a disability statement. So if somebody misses work, so say somebody's sexually assaulted, and that's a difficult, it probably is pretty difficult to go back to work. You're not going to go back to work the next day, or maybe the next day, or maybe even the next month, for whatever reason. I can, without a disability statement, and I'll say what that is in just a second, I can pay 2 weeks of lost wages. So I would just need documentation from the employer. So I'll send the victim, hey, give this to your employer and have them, fill it out. Then he or she can tell them whatever they want as far as why they missed work. I just need to know when they missed and how much they were making. And so without a disability statement, 2 weeks. Then if you have a treatment provider, a licensed treatment provider, that person can fill out, we have a form called a disability statement saying, yes, this person is unable to work, can work without restriction, or can work with restrictions this time to this time. That's really kind of all we ask. And then we require the treatment on proof of ongoing treatment. So we need the treatment records. So we can say, yep, they're continuing to get treatment for this crime, and we can continue to pay wages up to $6,000. So we are able to pay counseling and medical expenses that are not covered by insurance. So we are the payer of last resort. Everything has to go through insurance first. And if the provider is not covered by insurance, that's fine. Then we will cover the whole thing. We'll cover 100% of it. A counseling benefit, let's say, because sometimes people want, you connect with a therapist and they don't take your insurance, or maybe your insurance changes to an insurance that they don't take. We can, it eats up that $5,000 faster if we're paying the whole thing. But sometimes, there are some really good therapists out there that will, oh, I'll take a reduced rate because, I know Crime Victims is paying, things like that. So those are ways that we can help. I'm going to kind of gloss over this a little bit. If, we can talk about it another day, but we ask treatment providers to verify the crime-related treatment. And so even if insurance is paid, even if they're like, oh, I don't have any out-of-pocket expenses, I can still pay mileage and lost wages for attending counseling and medical appointments. This is the letter that we send them. This is the form that we ask them to fill out. Did they have insurance? Do they have an outstanding balance? For treatment providers, we get this question every once in a while. That signed release that has the 3123 on it, we're required to keep that law confidential, and they're required to give it to us if we ask for it. So we only request what we need to determine the eligibility, that yes, we're paying for crime-related treatment, and to consider the payment, yes, we're the payer of last resort. And so that signed release is sufficient to obtain that information. So this is kind of a repeat. We are not able to prepay. That's something to note. That's difficult for some people. We can, in the case of emergency relocation, that is a $1,000 benefit provided to crime victims. That relocation needs to take place within 30 days of the crime occurring, or I have to prove a good cause reason why it didn't. So if somebody's in shelter for 30 days and then moves into an apartment, it completely makes sense that they're going to be outside that 30-day window. However, I can't pay their deposit for them upfront. But if a victim serving agency, so an advocacy program, does pay for that, the advocacy program can bill our program and we'll pay it back, but it's only for that emergency relocation. So that could be moving expenses, bus ticket, airline ticket, boxes, tape, moving truck, deposit, any of those things. And there are no submission deadlines for treatment providers. So sometimes we get stuff from 3 years ago. Like some providers, they won't bill us for like 2 years and then we'll get 2 years of it. So, and that's okay. So these are the primary victim benefits. 5,000 counseling, 25,000 medical, lost wages for the crime-related injuries, and then you get on top of that is the $1,000 per person to attend court. Dependent care. Dependent care means if you had to hire someone to watch your child while you attended court or you attended a medical appointment or counseling, then we have a form for that child care provider to fill out. It's not, we cannot pay for if you would have taken them to daycare anyway. We can replace clothing and bedding held as evidence. We're hoping to get that amount updated, as it hasn't been updated since I think 2007. I heard yesterday. So these are the options. We do not provide housing assistance. Of note, the relocation is a lifetime benefit. So I had a woman who left a terrible situation, and she, with her 3 children, they all hopped on a bus and they moved to a different state, and she had to live in a hotel for a while until she could get a job and get herself settled. And so I was able to pay $1,000 of relocation expenses for her, $1,000 for each of her children. So she had access to $4,000 of emergency relocation benefit. However, now if one of her children someday down the road applies and wants to use that relocation benefit, they can't use it because it has been expended. These are the secondary victim benefits that we have. And so counseling, that's their own counseling. And then lost wages to take their child to, most of the time is child family member to dependent, to appointments, $1,000. Lost wages to go to court, $1,000. Transportation, lodging, those are the same for everybody, those other ones. Homicide counseling is $5,000. Medical is $3,000. Lost wages, again, $6,000. Dependent care is different than loss of support for dependents. So if a person is murdered and they have dependent children, I have to prove that that child is A, theirs, and B, that they have a responsibility to that child. The easiest way for me to do that is to see it on a tax form or to wait for the Social Security benefit letter. And then I can pay it off of that. So our application process, your application stays with the compensation specialist. So Lisa Bigglehop is my boss now, but I have her caseload from before. And so it will stay with me until someone else is me. But you keep that same compensation specialist through the life of that crime. Eligibility, typically 8 weeks or less. We really do a much better job. The thing that we wait on most of the time is getting those police reports or getting the statements from advocates. No time limit on benefits. That's a lifetime benefit. And so if, you know, I had a mom asking about this, she has young children. Later, if they need therapy related to the murder of their dad, well, yes, that would, all I have to do is show that it's connected to the crime. By the numbers, 2023, 5.3 million was paid to or on behalf of victims. We received about 6,000 applications. We rarely deny them, as you can see. Mostly we deny them for not being a covered crime. And so the primary application can be completed online. I think we covered that okay. I think you guys are pretty familiar with the difference between an advocate and a victim witness coordinator. I'm borrowing a little bit of a skeleton of a presentation from someone else, but crime victims feel better and they better recover when they feel supported by the professionals that they encounter. So, as you know, it's not best practice for you to be the only person caring for a crime victim. When they feel the support of their community and they feel like, okay, I have agencies around me that care and want to help, they're going to recover better. So I'm going to stop sharing my screen. Sorry, I just choked on myself. Get back here. Okay. So anybody have any questions, comments, thoughts, concerns? Woo, came right in at the minute. Yes.
Yeah, I did have one question, Brenda. So for instance, let's say I was raped and I received my $5,000 allowance for counseling and I maxed out.
Yep.
And then I were to be raped again, would then that allow for a new pot of like allowance for counseling and all those things, or am I just done with it at that point?
Yes, I'm a big liar because you asked me to cover that and I didn't. And I said I would. I'm so sorry. Yes. So benefits are tied to the specific crime. So that works with I am the victim of domestic violence. I have one that or sexual assault. And somebody violates the no contact order. The violation of the no contact order is a new crime and open to a new, then you get those benefits all over again. So I have a woman who was assaulted. Then he violates the no contact order twice. So I paid her lost wages for 2 weeks here, 2 weeks for the second one, 2 weeks for the third one, etc. So. Okay. Oh, thank you for answering. Access to the PowerPoint. Yeah, it is hard to remember everything. I promise you. I keep learning and learning and learning. I've been in the business for a couple of years and I'm always learning something new. So I hope that was helpful in kind of getting to know how our office can be helpful to the victims that you work with.
All right. Any other questions?